Members, this is the appointed time. We have a quorum. So I call this meeting to order. This is the meeting of the Bills Committee on Gas Safety Amendment Bill 2025. This is our second meeting. So item 1 on the agenda, meeting with the administration. Let us invite the administration to come in. And as discussed at the meeting of the 12th of May, the Secretariat of the Bills Committee already published a notice of invitation on the Electrical's website for the public to submit their written views about this bill. We've also sent letters to the 18 district councils. The deadline for written submissions is it's 5 p.m. the 26th of May 2025. Mr. Gary Chen, I need to declare that I am Deputy Chair of the New Energy Committee of Sinopec. I need to declare my interest according to the rules of procedure. Let me welcome officials from the administration. Now, we have a list of follow-up actions required arising from the discussion at the last meeting. Members may wish to refer to LC paper number CB bracket 2983/2025 bracket 01. And Mr. Zhang Chin King, Chief Engineer of the EMSD, will now reply to the matters raised as per paper number CB bracket 2983/2025 bracket 02. Members, if you want to ask questions, please press the request to speak button now whilst I give the floor to Chief Engineer Mr. Zhang. Thank you, Chairman. The administration has provided a written response to the items discussed at the previous meeting, and I'd like to make use of this infographic diagram to explain our points. Now, basically, members raised a question as to how regulated hydrogen will be distinguished from hydrogen that is not regulated. As you can see in the infographic, there is a distinction between regulated and not regulated hydrogen. Now, simply put, regulated hydrogen is defined as any gas that is primarily hydrogen used or intended to be used as fuel for the propulsion of vehicle or train. That's A. And also B, the operation of any machinery other than machinery of a vessel or aircraft. So any hydrogen that meets that definition will be regulated, and as you can see on the top right of the drawing, it will be regulated by the Gas Safety Ordinance as regulated hydrogen, and it applies to the whole chain, including importation, manufacture, storage, transport, supply, and use of regulated hydrogen. Specifically, you will find the examples shown in the following diagrams. For example, import of hydrogen, manufacture of hydrogen, vehicles carrying the regulated hydrogen, as well as the hydrogen refueling stations, the mechanics for repairing hydrogen-propelled vehicles. And then next row, you will see the relevant pipelines for the transportation of hydrogen, the storage, and also hydrogen operated power plants, the vehicles, trains, as well as machinery that runs on hydrogen as fuel. For hydrogen not regulated, that's out of scope hydrogen, the hydrogen will be regulated under CAP 295, the Dangerous Goods Ordinance. Now, this bill also covers amendments to the Dangerous Goods Ordinance. And the hydrogen, in such circumstances, will be excluded from the scope of regulated hydrogen under CAP 51. And as you can see, there are 6 scenarios. Hydrogen not used as fuel, including manufacture, storage, transportation, and also in the second row, hydrogen may be used as coolant of power plant generators. It may be used for laboratory purposes or medical purposes. And for non-fuel hydrogen, is distinguished from regulated hydrogen, and that appropriate marking and labeling should be applied to the hydrogen not used as a fuel as dangerous goods. And then on the bottom right, we have hydrogen not regulated under either CAP 51 or CAP 295, and they include, for example, hydrogen vessels. Now, this is covered by another piece of legislation. For ocean-going vessels, the Merchant Shipping Safety Ordinance applies. And for local hydrogen vessels, they are regulated under Merchant Shipping Local Vessels Ordinance. As for hydrogen aircraft, drones, they are regulated under CAP 448, the Civil Aviation Ordinance. For hydrogen-propelled drones, they are regulated under CAP 448G, and that is the Small Unmanned Aircraft Order. As for hydrogen balloons, it's actually helium, not hydrogen. The balloon flows upwards because of the use of helium, which has a weight lighter than the atmospheric air. And as a result, helium or hydrogen is not used as fuel. So first and foremost, is not regulated by CAP 51. And the gas used to fill balloons is exempted from the regulation under Dangerous Goods Ordinance. So, simply put, the hydrogen balloons are not regulated by either CAP 51 and CAP 295. Right, thank you, Mr. Zhang, the Chief Engineer. With the help of the infographics, members as well as the general public will have a better idea of the proposal. Now, there are 4 items that we wish to follow up on. The first one is for the administration to provide infographics, and that has been done. Now, also, we'd like to ask another follow-up question. With regard to emerging new vehicles, etc., there is a suggestion that the relevant unit talk to the working group on the development of low-altitude economy. I want to know whether such a discussion has taken place. Now, some members also mentioned setting up demonstration zones on an outlying island. I'd like to have an update on these 2 suggestions. Chairman, the first point relates to perhaps sea air or multimodal transport, and we have talked to the Transport and Logistics Bureau. According to their definition, if the mode of transport runs on air, then it will be subject to the regulation of this bill. And when this kind of conveyance flies up into the air, then it will be regulated by the Civil Aviation Department according to the relevant legislation. So this is the confirmation we've sought from the Transport and Logistics Department. Right, I think we covered the same point last week, and we were clear about that. At the same time, members raised some questions as to new kinds of conveyance equipment that travels both on air and on land. And our suggestion is that perhaps there should be some liaison with the working group on the development of low-altitude economy so that if need be, we can further revise the provisions here. Well, perhaps I'll give the floor to the EMSD. Chairman, if I may, I'd like to respond to this question. We talked about the multimodal conveyance transport. That means traveling in air and on land. And that has to do with the scope of regulation by the relevant departments. Say if we have this bimodal transport, and if it meets the definition of a vehicle, then it will be subject to the relevant legislation. And if this kind of vehicle runs on land using hydrogen as the fuel for propulsion, then it will be subject to the regulation of CAP 51. Now, if it flies in the air, then it's an aircraft. It will be subject to the Civil Aviation Department's purview. As far as low-altitude economy is concerned, if we find new drones that are propelled by hydrogen, or if it's a bimodal kind of drones, and then we will talk to the working group and then work out the regulatory framework. Well, I think that's all we should discuss on this matter. The point is that if we see new kinds of transport, we should follow that up with the working group on the development of low altitude. And also, please follow up on the demonstration zone on an island. Now, the other point is about definitions. The legal advisor issued a letter dated the 22nd of April. The legal advisor asked 3 questions. The first question relates to the definition of regulated hydrogen. We've received a reply from the EMSD. Now, my first question is, shouldn't there be a Chinese version of this letter? Because I see only this letter in English. And anyway, I will invite the legal advisor to briefly explain the points raised, including the question on definitions. Thank you, Chair. As the chairman just now explained, our division wrote to the administration. Members, please turn to CB bracket 2847/2025 bracket 02, which is about definition of regulated hydrogen. We invited the administration to clarify how a gas would be determined as consisting primarily of hydrogen, and whether other gases would be mixed with hydrogen, so on and so forth, whether it would be specified. Members may also wish to turn to 847/2025 bracket 03 for the reply. According to the administration, as long as it's any gas that is primarily hydrogen, it will be within the scope of regulated hydrogen. And that it is not necessary to specify the gases mixing with hydrogen in the definition. The other 2 questions have to do with drafting. We asked the administration whether it is necessary to revise the definition of specified entity, 指明實體, in clause, and also the other point in clause 6. Now, according to the administration, these 2 provisions are clear enough. There is no need to amend them.
Thank you, Mr. Zhang and legal advisor. So they have raised points about the questions we raised last time. I think from now on, we will try to allow members to raise questions. I'll list out the list of members who would like to raise questions, and we can discuss accordingly. First, Mr. Andrew Lam, Mr. Chan Siu Hong, and also Mr. Lai Tong Kwok. So far, these members would like to speak. We do have time, so I would allow 5 minutes for each member. Mr. Andrew Lam. Thank you, Chairman. I would like to go back to the definition of regulated hydrogen. I now have a better understanding of the definition, but I would like to know about the actual operation. We're not going to talk about hydrogen or the mixture of such, but I would like to talk about the regulated hydrogen and also the non-regulated hydrogen. This is a technical question. So what is the difference between the regulated hydrogen and the non-regulated hydrogen? So is the component of the two types of hydrogen different? If there is a difference between the two, so for the manufacturing, transportation, supply, storage of such, will the design for the two be different? If the components of the two types of hydrogen is the same, then I think we should apply the same set of arrangements. So if it is to be used as non-fuel, there will be a label. So I would like to know when the label will be applied. There may be a container for containing the hydrogen. It may be used for regulated hydrogen and non-regulated hydrogen. So you will just differentiate the two by looking at the label. Is there other ways to detect them? For the supply system, will the same happen? Because you may be using the same pipe to supply the hydrogen. Even for the manufacturing equipment, you may be able to also produce regulated hydrogen and non-regulated hydrogen. So I would like to know what will happen in the actual operation of the amendment bill. Thank you, Chair. Thank you, Mr. Lam. Administration? Commissioner? I would defer to my colleague from EMSD. Thank you, member, for the question. I think we're talking about regulated hydrogen and also hydrogen which will not be regulated. For the container, I think we'll start from there. Under CAP 295, there will be a label. Under CAP GSO, there will also be another label. So when we approve the container, it will be specified for a certain use and we will give them the relevant label. For example, under CAP 51, then EMSD will be the authority to approve such. And so you will get a label from the EMSD. So by looking at the label, you would be able to tell under what circumstances the hydrogen will be used. And for the hydrogen within the container, they can only be used for the specified purpose. For the components of the hydrogen under CAP 51, under the subsidiary legislation, we will specify the quality requirements for the hydrogen. So there will be a requirement in terms of the quality. But for CAP 295, there may be other requirements. And we will need to look at the exact circumstances then. So for the two types of container, they may be under different pressure, and the difference could be quite great. So under CAP 51, the Gas Safety Ordinance, the pressure may be up to 350 or even 700. But under CAP 295, the pressure will be much less. It may be 200 or below 200. So for the manufacturing process, there will be a difference, and we will have sufficient labeling to differentiate between the two types of hydrogen. A quick follow-up. We now talk about the manufacturing and the storage of the hydrogen, and there will be a difference between the two types of hydrogen. On application, would it be possible to use the two intermittently? No, it is not possible to use them intermittently. For the hydrogen to be used for hydrogen vehicles, they would have to comply with the labeling under CAP 51. Well, maybe a more precise question. If we look at petroleum, it is not allowed to use a certain type of petroleum, but it is being used, then what will happen? So my specific question is, for the regulated hydrogen and the non-regulated hydrogen, can the latter be used as fuel? So we're talking about the user, not the manufacturer. Well, when we go to the clause by clause, I will raise follow-up questions. So I would like to know whether the two types of hydrogen are interchangeable in terms of use. No, it is not possible. Thank you. Next, Mr. Chan Siu-hong. Thank you, Chairman. The administration has provided a response to the questions raised at the last meeting, and they have provided infographics that facilitates us to understand the amendments to CAP 51, and then also the consequential amendments to CAP 295. So the situation is much clearer. But then there are also questions on the details that I would like to raise. First, Mr. Andrew Lam has raised a question, and I think we may look at the specific provisions governing that later on. So you have a label, and what if the user has used the hydrogen for another purpose other than that stated in the label? Then what would happen? So how are you going to specify the labeling, and will you have penalty if people misuse it, i.e. not according to the labeling? Another question I have raised actually at the last meeting, but I'm not really satisfied with the answer last time. Now that we have the infographics, I would like to raise the issue again. We would like to know what exactly are the amendments to CAP 51. So regulated hydrogen is any gas that is primarily hydrogen, and it is used for the propulsion of a vehicle or train or the operation of any machinery. So there are different requirements under the definition. Last time, I have heard that there is no definition for primarily hydrogen, but you would adopt the standards being adopted by the trade. So if you use the HFC vehicles, you got to have a component of over 99.9% hydrogen. But from the point of view of the legislation, you should not be referring to the prevailing market arrangement to define what is meant by primarily hydrogen. Will you specify the requirements under the guidance issued by EMSD or the regulations? For example, for a gas, will you say that if it is complies, say over 50% hydrogen, then it will be regarded as primarily hydrogen, and then it will become a regulated hydrogen? Or you would not specify such an amount, just like the current drafting. If there is a scenario through the process, you are not able to produce 99.9% hydrogen, and you only have some 80% hydrogen, and you use that for hydrogen vehicle, will that be contravening the legislation? or what is defined as primarily hydrogen. I think for legislation, we have to be very clear. We cannot rely to the arrangements adopted by the market or the business. So would you consider specifying the percentage of hydrogen that will be regarded as primarily hydrogen? If there is a mixture of 2 or 3 gases, and then the hydrogen only comprise half of that, or it is larger in volume than the other 2 types of gases, then it will be regarded as regulated hydrogen and will be covered by the amended legislation, which is being used for the propulsion of a vehicle. So can you explain and elaborate a bit more on that so that the industry and citizens will understand? So I will stop here and wait for the administration's response before other questions are raised. Thank you, Mr. Chen. Government representative. Oh, thank you for the question. Hydrogen is being developed. At the present moment, we can see that the density of hydrogen that is being used as fuel is 99.97%. In future, there may be technology for having a lower percentage of hydrogen. That's why we want to maintain flexibility. And in the subsidiary legislation, we will state that clearer, and we will stay in the regulation on the requirements regarding the density of hydrogen to be regarded as regulated hydrogen. Also, we will have codes of practice promulgated in future, and with the development of the technology, we will try to specify the density of hydrogen in the COP under different scenarios. So for the main legislation, we would suggest that we use the word primarily hydrogen. Chairman, I understand that maybe you would have more details in the regulations and the COP. You may say that it is a certain percentage, and if the hydrogen exceeds a certain percentage, then it will be regarded as primarily hydrogen. So your answer now is that 99.97% is regarded as primarily hydrogen. This is looking at the issue from the point of view of quantity. But if I have a workshop and I have a measurement of the hydrogen and it is only about 80%, so that means it will not be regarded as regulated hydrogen. That will be even more dangerous. If they are not careful with the operation procedures, the results may be damaging. So for legislation, I think the paramount importance is to ensure safety. And I think from the point of view of science or engineering, if danger is going to happen, you would require them to apply for a permit and you would have to approve them. So I'm concerned that for the COP and the regulations, if you only state the percentage of 99.97% and you do not govern about the hydrogen level that is lower than that percentage, it will be even more dangerous.
Thank you for the further question. This piece of legislation is not only about the concentration of hydrogen. We have a complete mechanism. We require importers of manufacturers to be registered. Now, the hydrogen is, as mentioned, will be imported. So at the level of import or manufacturing, we will do our gatekeeping. For example, for a manufacturing workshop, our approval will be required, and we will also look at the safety measures and the facilities as well as quality assurance. All these will be subject to our approval. We also require import permits to be issued first. Even for containers, we will also scrutinize containers to make sure that at the upstream there'll be proper gatekeeping. Chairman, if I may, I know that my time is up. I still want to follow up on these matters. I think it's of importance because the most important point about enactment is that we don't want anyone to be inadvertently caught by the law, and we don't want legal loopholes to be exploited. And what I mean by that is that if you set a hard figure at 99.97%, above which the hydrogen will be subject to regulation, then as long as I obtain hydrogen from a supplier for processing in my own premises, and as long as I get all the licenses and engage trained personnel to process the hydrogen, then I still will be able to circumvent Cap 51 in the sense that I dilute the concentration of hydrogen to below 99.97% in the workshops, and only at the point of refueling or do I increase the concentration to above 99.97%, then I will be able to circumvent the law. And how would you address that? Thank you, member, for the questions. I'll take the first part, and then I'll see if the EMSD would like to supplement. According to the amendment bill, the definition is any gas that is primarily hydrogen. So in the first place, the gas you mentioned will be subject to our regulation. Now, if the concentration is below 99.97%, then it will be a breach of the provision relating to quality assurance. This will be set out in the subsidiary legislation. So if the concentration is below 99.97%, it will be in breach of the quality assurance provision in the subsidiary legislation. Now, about manufacturing the gas, if the manufacturer fails to apply for a license, then it is possible that this manufacturer has contravened the gas safety ordinance as well. I'll see if the EMSD would like to supplement as well. I can give you this example. In relation to LPG, there is also a similar quality assurance requirement. Now, we need the hydrogen to be of a certain percentage of concentration because it affects the efficiency of the vehicle. Now, if the LPG is not of great purity, then when used as a fuel, the vehicle may very well break down, and there may be all sorts of safety issues. And that is why we set out the specifications about the concentration of LPG to be used to propel a vehicle. So adopting the same concept when hydrogen is used as a fuel in the hydrogen fuel cell, we consider the purity as well. If the purity is too low as to affect the efficiency of the HFC, then there may be safety concerns of this motor vehicle. So we strike a balance and we consider whether safety requirements are met. And that is why we devised the corresponding concentration requirement. Chairman, now I was talking about an extreme scenario. In normal business practice, it is unlikely that a businessman out of the blue would dilute the imported hydrogen so as to circumvent regulation and to save costs and to only boost the hydrogen content at the point of refueling. Now, this shouldn't happen in a normal scenario. Still, I'd like the administration to go back and give it a thought about this amendment to Cap 51, because I'm still concerned about things that fall between Cap 51 and Cap 295, whether there'll be concurrent regulation or no regulation at all. I just want to make sure that there won't be any loopholes that will be exploited. Chairman, I just asked a number of questions and I need to declare interest, albeit not very relevant. I'm a senior advisor or consultant to CLP. Right, Mr. Chan, if you like, you can wait for another round. Let's move on to the next one, Mr. Lai Tong Kwok. First question about this definition of regulated hydrogen. Now, I wanted to save this question until we reach the clause-by-clause scrutiny, but since Mr. Chan Sil-hung already made a start and the administration already provided an answer, I'd like to piggyback on those. So, Chairman, just for clarity's sake, my point is this. This amendment bill introduces a new regulatory regime on regulated hydrogen. So the definition of regulated hydrogen is of paramount importance. There should be 100% clarity. I've actually looked at CAP 51, Gas Safety Ordinance, for the definition. Now, there is this definition for gas, including town gas, and there is no specific definition. So I then turned to the town gas website to know more about the composition of town gas, and it's quite peculiar because town gas comprises hydrogen, and the concentration range is from 49% to 51%. It's understandable we need to provide a margin for errors in the manufacturing process. Now, I make this point because the starting point for us is to check the definition of regulated hydrogen. So we need to check what gases are included. The legal advisor asked a question about the same wording, and as I understand, there is nothing in this amendment bill that defines the main components of hydrogen. I just heard an excellent reply from the administration. I was told that this will be explained when they come to make it subsidiary legislation. But I don't think this is a feasible option, not for this principal legislation or subsidiary legislation, because the Chief Executive in Council is empowered to make regulation on the following matters, including import, manufacturing, storage of gas, so on and so forth. The key word here is gas. Now, in relation to gas, the Chief Executive in Council is empowered to make regulation. If no gas is involved, then there is no regulation to speak of. If we take a look at the definition of gas, it means town gas, liquefied petroleum gas, natural gas, a mixture of any, all or any of the gases referred to above. So if I were to argue with you whether the gas is regulated hydrogen, then you must meet these criteria in the definition. However, the question is about the word primarily hydrogen. Exactly what concentration are you referring to? Is it 99.97% or 50 or 51%? It's not defined in the law, not in this bill anyway. Well, I think that there is a circular argument here, as I've just read out. In order to regulate that gas, one of the criteria is that it should be a regulated hydrogen. That means going to the root of the problem. You have yet to tell us exactly the percentage of hydrogen in the composition of that gas to be regarded as primarily hydrogen. Let's hear from the administration. Right, it's kind of philosophical. It's a circular argument. There are three kinds of gases in the Gas Safety Ordinance under the definition of gas: town gas, LPG, and natural gas. For natural gas is basically methane. For LPG is propane, butane, propylene, and butylene, and town gas is basically methane. So all these are defined in CAP 51, the Gas Safety Ordinance. Now, this definition has been in operation for 31 years, and it has been a major reference for the sector. Now, in relation to the development of hydrogen, basically in different places in the world, including the mainland, this is the major definition, and this is also what we want to do. We want to go by what is set out in the existing gas safety ordinance. And also to add on top of that, the latest development on hydrogen. In fact, under the gas safety ordinance, there is also CAP 51A, which sets out the composition of the gases. It doesn't specify the exact percentage of gases, but these parameters are set out in CAP 51A. So drawing on the existing practice in the gas safety ordinance as well as the proposed subsidiary legislation, it is our proposal to keep the definition of hydrogen as such. I'd like to interject, sorry, because Mr. Lai was asking about the regulation. Now, I understand how you formulated this bill, but I don't think you've answered the question. Chairman, can I supplement? I understand your usual practice. Unless there is a case authority which validates your existing approach, I think at this point, what is set out in the law, in the statute, is not tested in a court of law. Now, it's all right that the GSO was enacted 30 years ago. Nobody challenged it. But nowadays, there are judicial challenges. So I think the crux of the matter is this. We're only focusing on this part of the bill, but if other similar circumstances arise, I think the administration should go back and consider revamping the approach. Say, when you make a regulation, you should improve the drafting to enhance clarity. I don't know how this is to be done, but at least, for example, you can spell out the composition of the gases so as to address this issue. And in the future, you may wish to cater for market changes. It's all right. You can have negative vetting. What is standing practice is not really our consideration. Please go back and give it a thought. Any response? Just to supplement, the term primarily means the gas in that mixture that constitute the largest proportion. Mr. Chen just now mentioned some scenarios, say if it's 80% or if it's below 97.97%, then people may be able to circumvent the law. In fact, the way we've drafted the provision will give us flexibility such that as long as primarily hydrogen, it will be regulated. And if the quality of the gas does not meet our requirement, then it will be in breach of another provision.
Well, thank you, Mr. Lai, for the suggestion. We will consider that. We will try to see if we can include a similar provision under Section 8 when we work on the subsidiary legislation. We will try to consider imposing that requirement. Thank you. Next, Ms. Doreen Kong. Chairman, I agree with what Mr. Lai has said. For the current drafting, there will be an issue if it is drafted in that way under the current amendment bill. So I hope the administration will go back and consider it. I do recall that at the last meeting, I also raised question about the word primarily of hydrogen, because it may not be a definition that is understood by the general public. I think we have to look at the legal intent under Cap 1 or case laws. I think you have to go to DOJ and ask for assistance. If you want to amend the definition, that's better. Otherwise, I think you have to be careful, because the current drafting is very unclear now on the definition of regulated hydrogen. Well, you have said that under subsidiary legislation 51A, there are requirements. Well, we are now only having some minor amendments to the regulations. Well, I understand that you would like to defer the power to the CE, and the CE would have the power to make regulations in future. But under the current regulation, you now talk about the gas safety, air quality. For regulation B, it is about the gas supply. C is on installation and use, and D is on the registration of gas installers and gas contractors. I have looked at Cap 51 A, B, C, D, and they are not covered by the proposed legislative amendments. So you now say that under Clause 8, the CE has power to amend the regulations. So I would like to know what would be the timing for that. Having scrutinized the amendment bill, I'm also concerned when you will have the proposed amendment to the relevant regulations. I will defer to my EMSD colleagues. Well, thank you for the question. We are at the drafting stage, and we hope that in the first half of 2026, we'll be able to complete the draft legislation concerning the regulations that you've mentioned. Well, we will not amend the existing regulation, but we will have a new set of regulations governing the regulated hydrogen. Any follow-up? No, thank you. Next, Mr. Dennis Leung. Thank you, Chairman. We are looking at the infographics, and we are talking about regulated hydrogen. So what will happen to the hydrogen that fall outside this scope? Will they be governed by the Dangerous Goods Ordinance? Vehicles will also be involved in transporting the other types of hydrogen. So how are you going to differentiate between the conveyance vehicle for the regulated hydrogen and the non-regulated hydrogen, so that the members of the public will be able to tell the difference between them on the streets? Because the component of hydrogen being transported will be different. Well, Hong Kong is separated by the Victoria Harbour. We have the Hong Kong Island and the Kowloon Peninsula. So a lot of dangerous goods being transported cannot go through the tunnels. We now have 3 road tunnels. So for vehicles using hydrogen fuel cell, will they be able to use tunnels? Is the issue being regulated under the amendment bill, or are they governed by the existing legislation? Another question about the importation of hydrogen, or the hydrogen being manufactured in Hong Kong. If they are not allowed to use tunnels, they will have to be transported by sea. But for the infographics, some situation may not be covered by Cap 51 or Cap 295, and they may be governed by other pieces of legislation. So the EEB is now taking charge, and the EMSD is involved. The TLB is also involved. So who will be responsible for law enforcement? Because different departments are being involved. So how are you going to take forward law enforcement? Will you be conducting joint operations, or will you set up a new department? Because you have different pieces of legislation now, and there may be a situation that will be covered by another department and fall outside one department's scope. So can you give us some idea as to whether there are other loopholes that need to be plugged, there will be further legislative amendments required. Commissioner, for enforcement, I will defer to EMSD. Well, thank you. 3 questions. The first concerns the labels. Now for the transportation of CLP, we already have very clear labels, and we will try to follow the existing practice. So for vehicles conveying hydrogen in future, they will be clearly labeled. For the use of tunnels, vehicles conveying hydrogen cannot use the road tunnels. We have actually conducted a trial, and we try to transport them by vessels, and it is feasible to transport them across the harbor. For the vessels transporting hydrogen, at the moment, LPG are being transported to Hong Kong by sea on vessels, and enforcement is being undertaken by the relevant department. For natural gas, they are also transported by vessels to Hong Kong, so the enforcement is also undertaken by the relevant government department. So the several departments have been operating smoothly and coordinated with each other well. What about in future for the HVFC buses or lorries? Can they also use the tunnels? Is it possible for them to use the tunnel to go to the new territories, Hong Kong or Kowloon? For the hydrogen-fueled vehicles, they can use the tunnels. We have conducted a trial, and we have specified in our standards that they have to comply with the relevant technical requirements for the design, the installation, and the safety requirements. They have to comply with the certain requirements. For the HFC double-deckers, they can use the road tunnels. I think they are able to use all the tunnels that we have, or most of them. And we will try to adopt the same standard for assessing vehicles being imported to Hong Kong. Well, accidents may be unpreventable. If there is an accident, is there a mechanism within the government to deal with it, or have you conducted drills? Because there may be several departments involved. Would you conduct more trials to deal with such crisis situations? The EMSD and the FSD has been liaising and working closely. Let me use the example of hydrogen vehicles crossing the tunnels. We have been cooperating with relevant departments, and we conducted drills together. And we try to see how we can do rescue operations if unfortunately an accident happens. So we are working on that. Next, Mr. Tan Kap Yew. Mr. Dennis Leung has raised a question about the HFC vehicles and whether there will be any breakthrough like the HFC vehicles crossing the road tunnels, and it is found feasible. Well, for the legislation, the amendment bill, it is stated that even for, well, I do not want to use the word train, and they may be propelled by hydrogen in future. So for trains, they may also go through tunnels. So the pilot or the test that you just mentioned, does it apply to trains being propelled by hydrogen? Or would it be necessary for you to take time to study the case? Thank you, Mr. Bill Tang. Commissioner, for the train passing through tunnels, we have not covered them yet in the trial that we've conducted because the safety issues are more complicated and we need more time to study that. A follow-up, Chairman. I think another bureau has been liaising closely with you, the Transport and Logistics Bureau. They have been pushing forward several projects, and they want to go for green mass transit. Like in East Kowloon, in Hong Shui Kiu, they have different projects. And they are talking about they would promote a new energy train and they do not want to have overhanging cables which would take up space. So if your trial has not covered that, does that mean that the TLB has not been liaising with you that for these new mass transit systems, they may not be using hydrogen? Because for the projects that I mentioned, they are being rolled out. Commissioner, we will liaise with the TLB closely and collaborate with them. If there is the use of hydrogen for vehicles going through tunnels, we will try to follow up with them closely and also conduct risk assessments to see whether they comply with our requirements. Well, I know that you may not be able to give me an answer today. There are many government bureaus and departments. I hope that you will give us a written reply in future. So for train, if they are being propelled by hydrogen, what will happen if they want to go through tunnels? So what is the government's assessment of this situation? And whether you would rule that out because of safety concerns, or you are thinking that there may be a chance that you'll be using trains propelled by hydrogen in future and they'll be able to go through our tunnels? Because you've mentioned train in the amendment bill, so I hope that you will provide us with more information. Well, I think the word train is being stated in the amendment bill, but I think it goes beyond the scope of this amendment bill. And I think for new energy, it is being developed in Hong Kong and the world. And I think the department has to liaise with the other relevant departments. Maybe can you give us a written reply after the meeting? Well, we have used quite some time to discuss about the definition, but I think it is important because we are trying to propose a legislative regulatory framework, and it is important to see what is being regulated, and it will also facilitate the clause-by-clause examination. Now, second round of question, I will give members also 5 minutes per member. Second round, Mr. Chen Siu-hong. Chairman, I fully agree with your judgment. When we talk about this amendment bill and before we move on to the clause-by-clause examination, I think we have to be very clear as to what is being regulated under the amendment bill. So for some of the definitions, they need to be fully examined, because I think the more discussed, the clearer the situation will be. The administration's response has covered the use of town gas, natural gas, and LPG, and a mixture of the gases, and it is being stated in the GSO for several decades. But now we are trying to include a new category of gas, and it is regulated hydrogen. And that's why they have to have a definition of regulated hydrogen. But it is because of the inclusion of this definition, we are unclear as to what is meant by primarily hydrogen. Because for the other parts of the definition is clearly understood, like being used as fuel for the propulsion of a vehicle or train or the operation of any machinery. But the word primarily hydrogen is not clear. And we're told that in the future regulations, the components, the density of hydrogen may be spelled out. But today, we haven't seen the subsidiary legislation yet, and we do not know how it will be drafted. Well, the administration has used CAP 51A as an example. It is about the gas quality, and it has been used for a long time, covering natural gas, tank gas, LPG. If I got it right, I think regulated hydrogen will not be covered under 51A. It will be covered under the new set of regulations. But for the new regulation, will it be drafted with reference to 51A, like the density of the hydrogen or the pressure or the clarity or purity of hydrogen? So we need to know what is meant by primarily, consisting primarily of hydrogen means. I think this has been used for several decades to cover LPG and it's been working well, but it has not been tested by any court case. So I think we have to move with the time and we have to be forward-looking. We should take this opportunity to see how we can have a better definition. You have to consider what is meant by consisting primarily of. Can you let us know what are you thinking when you say consisting primarily of hydrogen means? Because you said that you have some 20 trial projects and you are trying to regulate them at the moment. But as a facilitator, we hope that with the amendment bill, we'll be able to have better use of hydrogen for propelling vehicles and operating machinery. And we want to excel in that area. So with the amendment bill, it may not be cover all the situations. So maybe I'll pause here, Chairman, but I would like to raise other questions.
Thank you, Mr. Chan Sil-hung. Yes. Who from the administration would like to take this question, Commissioner? I'll give the floor to EMSD to take this question. Thank you for the further question. It is true that the initiative can only be promoted after the subsidiary legislation has been passed and come into effect. I think members are concerned about the percentage and what the maximum should be. What we have in mind is that if it's above 50%, and if it's a mixture of gases, we need to check what these other gases are, because some gases in the mixture would cause the gas not to be able to use as a fuel. Right, Chairman. Riding on the same point, Mr. Lai Tong-kwok just now quoted another example, that's town gas. We know that hydrogen density in town gas is around 49 to 51%. Now, if the gas is used for cooking, then of course it's not subject to the regulation here. What happens if the town gas company uses or extracts hydrogen from certain sites or through certain equipment and then refills the hydrogen fuel cell with the hydrogen extracted for power generation at the site, then hydrogen will be used as a fuel. And then if it goes above 50%, then it will be subject to regulation. Like Mr. Lai Tong-kwok said, it may not be exactly 50%, it could be 49%. If it drops below 50%, then there is ambiguity as to whether this piece of legislation applies. Then how are you going to apply this to the trial projects of town gas? Now, what town gas company does is to extract hydrogen from town gas, and the density or a concentration actually reaches slightly above 90%. And only at that level of concentration can hydrogen be filled in the hydrogen fuel cells for use as fuel. And that will become regulated hydrogen. For the rest of the gas mixture, it remains town gas. And town gas mostly primarily comprises of methane as well as hydrogen. I'm sorry, Chairman, another question. What happens if there is a pipeline? Because town gas has a demonstration area at the site, and the hydrogen content through that pipeline may reach a concentration of 51%. So what if town gas company conveys hydrogen through this pipeline to the site before the extraction takes place. Then what happens during the transportation of town gas should be subject to regulation, right? Now let's say town gas is transported to a refueling station, then town gas during the process will be subject to the gas safety ordinance, whereas the extraction of hydrogen from town gas will be subject to the amended gas safety ordinance. Next, Mr. Lai Tong Kwok. Chairman, I'd like to have your take on this because it seems that our discussion is themed on the 3 points raised by the legal advisor. Now, I do have some other questions. When we come to the clause-by-clause scrutiny, we will touch on the questions raised by the legal advisor about definition. So I'd like to have your take as to whether I should raise these questions now or later. Well, I think the legal advisor asked 3 questions. The second and the third questions relate to technical amendments and the drafting approach. So we will save those for the clause-by-clause scrutiny. Actually, I have some questions, but I will give the floor to Mr. Chen Zhe-hong for the third round first. Right, I have a similar question, whether I should raise this question now or whether I should wait until we start the clause-by-clause scrutiny. My question was on what gas means, and that touches on the power for the Chief Executive in Council to make a regulation. I want to know whether the definition of gas in the subsidiary legislation will tally with the definition in the principal ordinance and whether it covers regulated hydrogen. Otherwise, I think we should reconsider this provision that is foreseen Council to make a regulation. Now, Chairman, perhaps I will save this question until we reach that part. Right, I'd like to pick up on the points raised by members. I have a similar question. The first is about definition, because as you mentioned, the word primarily, it means the gas in a gas mixture that constitutes the highest proportion. So I want to confirm if my understanding is correct. My second point is this. From the point of law, as per our discussion, if the concentration falls below the criterion, then it will be in breach of the gas quality provisions. But I think we are mostly concerned about gas safety. Now, I know if it falls below certain concentration, it is a gas quality issue. But the gas quality regulation looks after the quality of this merchandise. It's not about safety. I don't think this argument stands water because I don't think the two pieces of legislation safeguards the same thing. So that's a point of clarification. My third point is this. I'd like the administration to give it some serious thoughts. Mr. Lai Tong Kwok, in his first round, referred to a circular argument. That is, whether C in Council does have the power to make subsidiary legislation. Now, I see a legal hazard here. In fact, Mr. Lai Tong Kwok specifically made a suggestion as to how this should to be amended. So, can you help me clarify these 3 points? These are similar to the matters already raised by members. Thank you, Chairman. Well, as it literally suggests, primarily means the primary component of the gas. So if it doesn't reach 99.97%, then it will be subject to our regulation because of the quality issue. Because it provides that the gas for sale should meet the gas quality requirement, that's 99.97%. And if it falls below 99.97%, there is also a safety concern. So this will be subject to our regulation. And on top of that, it fails to meet the gas quality requirement, so it cannot be used for sale. So a further question, let's say if it's 51%, then of course it's the primary component. Let's see if it's a mixture of 2 or 3 gases. Can I take it that if it constitutes 40%, with the remaining 2 being 30 and 30%, then it's still primarily hydrogen? Say if there is a 40% hydrogen content in a mixture, and it's a mixture with inert gases, then some may be of 30%, the other may be 20%. If hydrogen remains the major component of this gas mixture, it can still be used as fuel. It may not be efficient enough to run, let the battery run or use as a fuel. And our primary concern is safety, and we're concerned that this level of concentration may have quality issues and may be unsafe for the propulsion of vehicles or machinery. And that is why the gas must meet our safety requirements. Failing which, the relevant persons may be prosecuted under the relevant subsidiary legislation. Right, another follow-up question. I understand your logic and the concept. You talked about the level of purity and that it may not be high enough to propel a vehicle, but for safety's concern, this will be regulated as well. In fact, you can expressly provide what you've said in the bill so as to address Mr. Chan Sio-hung's concerns. What is the reason why this has not been adopted in the bill? I think we've been arguing about the same point for quite some time now. We are concerned mostly about the subject of regulation. And in fact, it's quite a straightforward concept that, as you mentioned. Chairman, if I may supplement, regulated hydrogen means gas that is primarily hydrogen. This may be a gas mixture. Now, if the hydrogen content is less than 50% in that mixture, and if it constitutes the main component, and then it is still primarily hydrogen. Now, in another scenario, if hydrogen content doesn't constitute the largest component in this gas mixture, we need to take a look at what gas mixture we're talking about. There may be different gases mixed, and there is then a question whether it is still called hydrogen. Right, albeit not a major component in the gas mixture, if we're concerned that the level of concentration may not support the use of gas as a fuel and it should be regulated. That's the logic, right? So the definition is quite clear. As long as the major component, then it's regulated.
Looking at that.
Well, Chairman, there are actually several requirements for being regulated. First, it has to be primarily hydrogen. Second, it has to be used as a fuel. Even if the component of hydrogen is the largest, but if there are other gases which render the gas no longer able to be used as a fuel, then it will not be covered, regulated. So this is different from the version that we just heard. So you have to clarify. So you actually have two conditions. You have to say that even if it does not be, we will not be able to be used as fuel, it still has to be regulated for safety reasons. Is that correct? Is that the case? Mr. Chen Xiu-hong? Well, Chairman, thank you for giving me another round to raise questions. Well, this is a very important point. I think we have to use a more scientific approach. Well, our concern is that we have to ensure safety. Safety should come first. Then we talk about quality. Well, to ensure safety is something very scientific. If you say primarily hydrogen, you may be talking about some 30% or 50%. But if for a mixture of gases, if there is 10% hydrogen and there will be an accident, then you may give rise to casualties and loss of properties. So that's why we have to regulate it. So if we adopt a scientific approach, then we should be looking at the density. We should be having a percentage of the density to see whether the risk is high or low. So for dangerous goods ordinance, you also cover different substances, and some of them are of a lower category of danger. So first, the chairman has touched upon a scenario, and I hope the administration can go back and really have a rethink. Think about your legislative intent. You want to cover a gas that is consisting primarily of hydrogen. If you're looking from the issue of safety, ensuring safety, you have to see how you are going to describe that in the regulations. Second, I think I have come across some mainland regulations concerning hydrogen. We can also look at the case in the US and Europe. So they will have different definitions. Can we make reference to those definitions? Because now we are just asking questions about the current drafting of the definition of regulated hydrogen. You've been telling us that the GSO has been operating well to cover town gas and other gases. But if we want to include hydrogen, and they have to be regulated together with LPG and other gases, so there is a chance for us to look at the matter afresh. So let's see if it is necessary to have the component of the gases, the percentage of such being stipulated under the definition. We should look at it from the perspective of ensuring safety. Any response from the administration? I agree with the view of members, and we will go back and consider the matter together with the department as to how we can improve the drafting of the definition. Well, to summarize, I think we have used over an hour to discuss this issue. First, we can see that the current drafting may give rise to concern amongst members because we have to state very clearly what will be regulated by the proposed regulatory regime. So we hope the administration can look at the drafting of the definition of regulated hydrogen to make it clearer, to spell out what is clearly meant by consisting primarily of, and also let us know how you intend to draft the relevant regulation. Secondly, several members have pointed out that there are other gases which is being governed by the GSO and that have been operating for several decades. But because now we want to include hydrogen, so there is a chance for us to look at the issue afresh. So there may be some loopholes that need to be plugged. So let's take this opportunity to look at GSO and review the GSO as to how we can enhance it. So this is the intention of the Bills Committee, and we want the legislation to be more comprehensive. Thirdly, Mr. Lighton Cobb has touched upon the power for making regulations. He said that there may be some risk, so please look at that as well. So this is a quick summary, but I think by the end of the day, we have to be clear what will be governed by the proposed legislation. The more we debate, I think the clearer the situation will be. So do members have any more questions? Anything that you want the administration to go back and follow up? If there is no further questions on the administration's response, then I think we have discussed all the policy matters, and we will move on to the clause-by-clause examination of the amendment bill. And also, we may touch upon some of the issues that we have just discussed. If there are no further questions, I think we'll discuss both the Chinese and the English version of the amendment bill. Members who would like to speak, please press the button. First, let's refer to the Blue Bill, CB bracket 847/2023 bracket 01, the preamble and also clause 1 and 2. Commissioner, can you introduce the provisions to us? I will defer to my colleague from EMSD to take us through the clauses. Well, first, the purpose of the bill. The bill aims to amend the Gas Safety Ordinance to establish a regulatory framework governing the importation, manufacture, storage, transport, supply, and use of hydrogen that is used or intended to be used as fuel, and to provide for the related amendments enacted by the Legislative Council. The preliminary Clause 1 is the short title and commencement. This ordinance may be cited as the Gas Safety Amendment Ordinance 2025. 2. This ordinance comes into operation on the date to be appointed by the Secretary for Environment and Ecology by notice published in the Gazette. Amendments amended. The amendments specified in Part 2 and 3 are amended as set out in those parts. So for Part 2 and Part 3, it is talking about the amendment to the Gas Safety Ordinance and the relevant technical amendments. Any questions from members? Mr. Andrew Lam. When we discuss, can we abide by the markup copy when we do the clause-by-clause examination? Yes. Please continue. Chairman, should I defer to the paper with the numberings 001, the markup copy? It's paper CB bracket 2847/2025 bracket 01. Yes, that's correct. So now I would go on to Part 2. It is the amendment to the Gas Safety Ordinance and the related technical amendments. Well, let's refer to the page numbers of the English and the Chinese version when you go through the clauses so that we can make easier reference to that. Yes, I'm now on 001 of the Chinese version. Part 2, Amendments to the Gas Safety Ordinance and related technical amendments. Division 1, Gas Safety Ordinance, Cap 51. We will amend Section 2 the interpretation section concerning decommission. So for the definition of decommission, so we would include after gas installation, hydrogen installation or hydrogen system. And then after that, we will also include the words or system. So this is the amendment to the definition of decommission, and we want to add hydrogen installation or hydrogen system under the definition. Then the amendments to the definition of gas. In C, we would delete the word or, and then for D, we would delete the subclause, and we will have a new D and E. It is a mixture of all or any part of the gases referred to in paragraphs A, B, and C, or regulated hydrogen. So the purpose of the amendment is to include regulated hydrogen in the definition. So I think some members have questions. Mr. Andrew Lam? Chairman, for decommission, you include hydrogen installation or hydrogen system. My understanding is that hydrogen installation and hydrogen system and hydrogen pipes, there are definitions for such terms. I noticed that for hydrogen system, it is not referred to regulated hydrogen. But for hydrogen installation and hydrogen type, you do make reference to regulated hydrogen. So I would like to know why there is a discrepancy between the two. So does that mean that hydrogen system will cover non-regulated hydrogen as well? If that's the case, then I would like to know why. Thank you. Well, here we talk about hydrogen installation and hydrogen system. Actually, both of them touch upon regulated hydrogen. Maybe I'll give an example. Well, there will be a definition of hydrogen installation in the latter part of the amendment bill. For example, for the stations, it will be receiving imported hydrogen and it will be regarded as a hydrogen installation. For hydrogen system, maybe the HFC will be covered by the hydrogen system. So for the definition, we want to include hydrogen fuel cell under hydrogen system. So for both terminologies, it will be related to regulated hydrogen. Well, sorry, can I jump to page 8 and 9? I don't see a reference to regulated hydrogen there under hydrogen system. Why? If you are trying to cover regulated hydrogen, why don't you state it clearly here that you are talking about regulated hydrogen system and regulated hydrogen installation? Thank you. I'll supplement. Under hydrogen system, there is clause A1. We talk about a hydrogen container. And for the definition of hydrogen container, it is stated clearly that it covers regulated hydrogen. So we are trying to cover the issue layer by layer, and you will be going to regulated hydrogen.
I understand this drafting logic, but since the objective is about regulated hydrogen, I think you should spell it out very clearly instead of a layering of definitions here. I'm puzzled. Well, this is my feeling on reading the text. Now, earlier, I said that I'm going to raise some specific questions when we come to the clause-by-clause stage. Installation and system. Just now, I heard very clearly that regulated and non-regulated hydrogen are two different things. They are not interchangeable. Now, for town gas, in transporting town gas, the gas may be mixed with other gases, and then comes the extraction process. Regardless of the percentage of hydrogen, is it that the hydrogen extracted immediately becomes regulated hydrogen? That's the first question. Second question, according to my observation, gas may be pressurized to different ATMs for different purposes. Now, in the process of pressurizing the gases, will there be a distinction between regulated and non-regulated hydrogen? I know that there will be different labeling and marking according to the amendment bill. So be it a hydrogen installation, be it a supplier or a manufacturer, these individuals will need to make declarations according to the relevant legislation in order to get approval and to apply the appropriate labels. So that's a question on hydrogen installation and the hydrogen system. I think that you will achieve the best clarity if everything is regulated hydrogen. It is true that this amendment bill covers regulated hydrogen. As to when town gas will become regulated, manufacturing of hydrogen actually falls within the scope of this bill. So if it involves manufacturing of hydrogen, then it will be caught by this law. Anything to add, Ms. Chan? Now, I stand to be corrected, but the member seems to suggest that we add regulated in front of the term hydrogen so as to provide better clarity. I thank the member for the suggestion. In the drafting process, we considered a number of things. For example, this term is like a label. Now, we want to achieve, I want things to be straightforward and easy to understand. So by including too many words, the label may become too long. Well, I understand your explanation, but I don't accept it. It's very easy. You can just add this word regulated in front of hydrogen. Now, it's not just about adding regulated to hydrogen. This term will crop up repeatedly throughout the bill, and the word regulated may appear very frequently, and this may clutter the bill. Well, my take is that we need a clarity first and foremost. To say that adding the word regulated before hydrogen makes the bill very cumbersome, then I don't think I can agree. I don't want to criticize the government. I just want to make things clear. And this is, anyway, my view. I hope that you give it a careful thought. Right. Would the DOJ representative please go back and give it a thought? Perhaps if you include this here, it won't be too cumbersome. If later on you use the short form instead, just put things in a bracket. Well, Chairman, I don't read law, but I've read a number of them. If you say that there is another drafting approach, and so be it. Perhaps you can put it down here and put it in a bracket. It's my suggestion. Right, noted. I think Ms. Chan has heard you loud and clear. Next, Ms. Doreen Kong. Chairman, I agree with Mr. Andrew Lam's suggestion. I think it's easy to add this word in front of hydrogen, just like installation and then hydrogen. I don't think it's a difficult task to add regulated in front. Now, I'd like to ask a question about the commission, which includes hydrogen installation and hydrogen system, and some vehicle parts may be included here. And then it says here under decommission in a safe and orderly manner. So in the context of a vehicle, what does it mean by decommissioning a vehicle? I think this term is crucial because I think 13A refers to decommission as well. That is, in fact, after receiving the improvement notice under 13AA, capital AA, I may choose to decommission the system in order to meet the requirement. So what is meant by decommissioning? Does it mean taking out the cylinder or not using that vehicle? Thank you for the questions. In the context of an HFC vehicle, we're talking about the extraction of hydrogen from the tank or degassing without regulated hydrogen in the cylinder or tank. The hydrogen cannot be used for fuel as fuel to propel the vehicle. Excellent, Chairman. According to the definition of decommission here, I didn't realize that hydrogen will have to be extracted from the cylinder. As an average Joe, I just read what it literally provides. It should be done in a safe and orderly manner. I should think that in order to do it in a safe manner, I should just let the system rest and not use it. Let me supplement. We're going to promulgate technical guidelines on decommissioning the vehicle. Now, let me give you an example. We have LPG vehicles. We also provide technical guidelines to the sector for decommissioning these LPG vehicles. We also have codes of practice to spell things out. It's difficult to provide express definitions here for each and every types of vehicle. That's my suggestion, Chairman, but I'm sorry to go on. Let's say if I buy an HFC vehicle, apart from reading the manual, I need to make sure that I comply with the law and the code of practice. And that I need to get a license, for example. It's just a suggestion. I don't think things are clear enough. Thank you, Ms. Doreen Kong. This is an amendment bill on hydrogen, and I think the administration has drawn reference from other legislation on other gases. I understand the need for flexibility and that we should not just stick to the usual practice. I think as far as the law is concerned, we need to provide clarity and make it more user-friendly for the general public. Mr. Tony Chair. Thank you, Chairman. This is my question. It's quite straightforward. I'd like the administration to explain the following. I see in the interpretation clause, regulated hydrogen is now added. If the definition of gas already includes regulated hydrogen, then why do we need to spell out hydrogen installation or hydrogen system in a definition of decommission? Thank you, Chairman. The original definition of decommission goes like this. It says notifiable gas installation. And it refers to gas installation of the three gases being regulated. So what we do here is that we add hydrogen installation or hydrogen system in the definition of decommission as well. Mr. Tony Chair. What I'm saying is, if gas here already means regulated hydrogen as well, then is it really necessary to amend the definition of decommission as such? Because it already refers to gas installation, and then gas already means regulated hydrogen. Why do you need to expressly provide hydrogen installation or hydrogen system? And why not town gas installation, LPG installation as well? In fact, for notifiable gas installation, there is another definition, and it does not include regulated hydrogen. That is why we need to distinguish between regulated installation and hydrogen installation. We can't use a catch-all definition. Well, for the benefit of the general public, I do look forward to a better explanation. Let me supplement, Chairman. If I may, we consulted the industry. We briefed them on the amendment bill, and according to the industry, they would not want the existing operations to be affected. There are three types of gases: town gas, LPG, natural gas, and according to the industry, the installation or system for these three gases should not be affected. And that is why we've kept the notifiable gas installation and the definition for it to apply to only natural gas, LPG, and town gas. And that is why we've provided an additional terminology, hydrogen installation or system. Next, Mr. Chen Xiu-hong. Chairman, Mr. Wong just referred to the essence of the bill. Some members have found this part perplexing because they may not be as familiar as you when it comes to electrical and mechanical stuff. And as you mentioned, say for LPG, it's been under regulation for many years, and like Mr. Wong said, it's only reasonable that no major changes should be made to that system because it's a well-established and effective system according to the industry. And that is why in amending this bill, you've come across hurdles. And then in some particular provisions, we see other than regulated hydrogen in brackets. It's quite a tedious task to add these expressions and for us to examine them. But like Mr. Wong said, I think the reason behind is because of the industry's views. They would not like the existing mechanism to be affected. Our members also ask some reasonable questions. For example, why would you add hydrogen for installation of system under the definition of decommission? So, Chairman, I do hope that the administration will have patience in taking us through the nitty-gritty, as including why we should add, for example, other than regulated hydrogen in brackets. Because in the context of LPG or natural gas installation, this definition fits perfectly. But when it comes to regulated hydrogen, it doesn't work, and that is why it's put in bracket, and then you add another definition to fit that scenario. Chairman, anyway, I have a question to pick up on what Mr. Andrew Lam just now asked. I'd like to take another perspective. Why is it that the administration has added the word hydrogen in front of installation or system but not regulated hydrogen? May I take members to page 8 about hydrogen installation and hydrogen system? Hydrogen installation means that it already includes regulated hydrogen. So I don't see the need to spell out regulated hydrogen in the definition of decommission. I think we will soon come to the definition of hydrogen installation. So I may as well ask the question now. It doesn't say in black and white it is regulated hydrogen. I mean, the title does not suggest so, but if you look at the subpoints thereunder, you'll find the term regulated hydrogen. So perhaps the terminology should be changed to regulated hydrogen installation altogether before you set out all the subpoints here. For decommission of hydrogen installation or system, you can actually refer to page 8, and in fact, all of them refer to regulated hydrogen.
Before asking the administration to respond, let's talk about housekeeping matters. The meeting is originally scheduled to end by 6:30, but because the main council meeting has been extended, so if members agree, then I would like to extend this meeting by 15 minutes so as to compensate that we have started the meeting later than expected. I would like to add that I fully agree with what Mr. Chen Xiu-hong has said. I hope the administration is not having an easy task. I think the colleagues at DOJ has been working hard too, because they have to talk about the existing operations and they also have to take into account new energy. So I do hope that together we can try to make this piece of legislation better. I noticed that this is not an easy task. And I think it is easy for the members of the public to understand. This is a very difficult piece of legislation. Administration, please, to respond to Mr. Chan's questions. Well, thank you, Mr. Chan, for explaining the situation. When we try to think about the amendment bill, we have several directions, and we have listened to the views of the industry. And we have also looked at the relevant legislation in the mainland and overseas, and also the development of hydrogen as a fuel in these places. So that's why we have adopted this current model. This is actually the quickest way to include regulated hydrogen under the current bill. Otherwise, it will take a much longer time to draft a new piece of legislation. Mr. Chan has raised a second question that is about the definition of hydrogen system. He asked whether it is possible to include regulated hydrogen there. I think the DOJ has talked about the situation. I think we would go back and see how we can make the legislation more readable to members of the public. Thank you, Mr. Wong. Please go back and consider the issue together with DOJ. And also, please take into account the views raised by other members. Next, Ms. Doreen Kong. Chairman, I have a question about gas. For the English version, you have the wording of whether in the form of a liquid or vapor. I think this is a very strange drafting. Why don't you include a word of gas there? Because here it seems that gas is not included. You only cover liquid or vapor. Should you say whether in the form of gas? So it doesn't really look appropriate to me. Because you're talking about vapor here, I think it is also very strange for the Chinese version as well. Well, I'm not a scientist, but I have looked at the scientific articles on the web, and I know that there is hydrogen in the form of solid and not gas. So is that being used as fuel as well? Can that be used as fuel also? Thank you, Ms. Kong. Maybe DOJ can take the first question, and then for the second question, we'll defer to EMSD. Senior Counsel, Ms. Chen. We actually have been working on the existing provisions. The wording that you talk about is actually in the existing legislation. Maybe I will go back and look at the matter. I will need to go back and study it. Well, thank you, Ms. Kong, for the question. I think in the world, so far we don't have hydrogen in solid form because it is not possible to have such. But for the information that you look at the web, is hydrogen mixing with other metallic components. So it is not hydrogen. It is actually hydrogen mixing with solid metallic components. So it is a form of dangerous good. Maybe it's not really a dangerous good, but it is not possible for hydrogen to appear in solid form. So is it covered by the Dangerous Goods Ordinance if such is found in Hong Kong? Well, we couldn't have solid hydrogen found. But if hydrogen is mixed with other metallic components, then that chemical substance will be covered by the Dangerous Goods Ordinance if it is dangerous. But if it is not a dangerous substance, then it will not be governed by the DGO. Well, maybe I'll forward the relevant journals to you because there is really solid hydrogen. Well, I think this is a very good meeting. We touched upon scientific findings as well. So any further questions on the section so far? So to wind up, would the administration go back and consider the suggestions raised by members and refine the provisions? Mr. Chen Xiu-hong? Chairman, to supplement, we are talking about the definition and the definition of regulated hydrogen. When we talk about the policy and when we talk about the clause-by-clause examination, I think the administration should really go back and consider our points concerning regulated hydrogen, the definition of it. And so that to put our hearts at ease, I think the definition of regulated hydrogen really need to be thoroughly examined so as not to raise misunderstanding. If the administration has other thoughts on how to define the regulated hydrogen, then you may be talking about the purity or the density of hydrogen. Please go back to us and let's discuss it. So let's say that the administration will go back and look at the definition again. Well, thank you, Mr. Chen. Well, I think a lot of members would like to speak. I don't think we have sufficient time for discussion. If members have no further questions, I think we'll finish the meeting here, and we hope the administration would go back and provide us with the supplementary information required by members. And also please take into account the views raised by members and discuss with DOJ as to how you can refine the provisions so as to avoid any misunderstanding. So let's allow some time for the administration to take follow-up action. We'll finish the meeting here, and we have actually set aside time for the next meeting, which is the 2nd of June in the morning, 10:45. We'll have the next Bills Committee meeting. If members would like to move any CSAs, please pass them to the Secretariat. If there are no further meetings, the meeting will be adjourned. Thank you.